Hello. This podcast is designed for teachers and teacher candidates who are studying in the College of Education at the University of Nebraska at Kearney. The information in this podcast is designed to help teachers and teacher candidates to understand the basics of U.S. copyright law and the exceptions to that law that may apply when copyrighted material is used for instructional purposes. Let's begin by looking at the basis for the law in the U.S. Constitution. Any law that is enforceable in the United States must be authorized somewhere in the Constitution. This is a good place for us to pause and look at the U.S. Constitution to find out where copyright is authorized. Please pause this podcast, then go to the website noted on this page to find which article and section might apply to the protection of writing and other expressions of thought through the U.S. Constitution. You should have found the wording shown on the screen in the U.S. Constitution under Article 1, Section 8. This section deals with the powers of Congress and spells out the purposes for copyright and patent laws. In layman's terms, the Constitution is telling us that we want people to be able to make a living by using their creativity to come up with writing and inventions that can generate an income for them. The Constitution also states that the Congress can pass laws that will give the authors and inventors an exclusive right to make money from their creations. Now let's look at a little historical context for the copyright law. As with much of U.S. law, the original concept for copyright came from Great Britain. Copyright was important enough in the original states that many of them had laws even before the formation of the federal government. In fact, our copyright law was one of the first laws passed by Congress after we ratified our Constitution. This tells us that this concept is very important to us in this country. A reading of the copyright law would reveal that copyright owners have 6 exclusive rights. By exclusive rights, we mean that the rights belong to the copyright holder and to no one else unless transferred by the copyright owner. We will now take a look at those 6 rights. The first right is the one that gives the copyright law its name. This first right is the right to make a copy of the work. This is the fundamental right because the ability to make copies is necessary in order for someone to make a living from selling her work. The second right is the right to prepare other works that are a direct derivative of the original. Examples of derivative works would be sequels to movie plots and successive books in a series of novels. We should note here that it is perfectly legal to use other people's copyrighted work when collecting background material for some new and unique work that you are creating. What is illegal is to actually copy all or part of another person's work and claim it as a part of your own work. The third right given exclusively to the owners of a copyright is the right to distribute those copies to the public by selling, renting, or leasing them. Only the owner of the copyright can sell, rent, or lease these materials. Some copyrighted material, like plays, dances, music, and movie scripts, are designed to be performed publicly rather than just being read. The owner of the copyright is the only one who has the right to perform the work in public. This is the fourth right granted by the law. The fifth right applies more to things like paintings and sculptures that are designed to be displayed in original form. Only the holder of the copyright can legally put on a show to display the work in public. The sixth and final right is the newest right that was added when digital recording of music and dramatic performances became possible. The holders of the copyright now have the exclusive right to perform the work by digital audio transmission. Digital audio transmission includes things like playing a song over the radio or transmitting the work to another place via the internet or by satellite. Reading these 6 rights might make us think that only the original copyright owner of a work is allowed to do anything with the product. It is important to remember that the copyright owner can always sell or give away permission to another person to use their work in any of these ways. That is how creative people can support themselves and their families by selling licenses to other people to use their work. If we go back to the actual wording of the Constitution, we'll find that it specifically states that there must be a time limit on copyright, after which the work becomes a part of the public domain and can be used by anyone. The time limit has changed over the years, but currently stands at the life of the author plus 70 years. This ensures that the heirs of a creative person can continue to gain the benefit of the person's work for a couple of generations beyond their death. So our next question may be, what do we have to do to create a copyright? This process has also changed over time. In the beginning, a person had to file paperwork with the U.S. Copyright Office in order to establish a copyright. So much creative work is now being produced that the current law states a work is automatically copyrighted as soon as it is fixed in tangible form. This means that your notes in this class and this podcast are automatically copyrighted as soon as you write them down or record the podcast. It is important to note that a person cannot claim a copyright on their ideas and thoughts because they are not fixed in tangible form. Class discussion would also not be copyrighted unless someone recorded the discussion to fix it in tangible form. The penalties for infringement of copyright law can be severe. In general, the penalties go up if someone is aware of the copyright law and if they make money for themselves by copying and selling someone else's work. In recent years, many college students and other people have faced stiff penalties because they copied music and distributed it over the internet. Even if they didn't make any money on the music, they could still be fined up to $100,000. Most people probably agree with the copyright law's protection of a person's right to make a living and feed their babies by selling copies of their creative work. But what about the use of copyrighted work in the classroom? Should there be some exception for teachers and students who are just using the work for educational purposes? Over time, a body of case law has developed that is now referred to as the doctrine of fair use. Basically, the fair use doctrine says that it is permissible for a person to copy something they own for their own use. It is considered a fair use for a person to rip music from a CD, for example, and play it in an MP3 player on their iPod or in their car, as long as that does not go outside of the person's family and as long as they don't make money from it. At this point, let's take a look at the University of Nebraska's guidelines for fair use in educational settings. Please pause this podcast and go to the folder on Blackboard for this module and open up the university's fair use checklist. The fair use checklist is designed for teachers to use when they are making a decision whether or not they can legally use a copy of something in their classroom. On the checklist, the factors that the courts have generally ruled to be in favor of the teacher in fair use cases are listed on the left side of the page. Those things listed on the right-hand column have generally been considered by judges and juries as working against you. If you can circle more things on the left side of the page than on the right, then you have a better chance of winning your case. If you fill out the checklist and find out that you circled more things on the right side than you did on the left, you should probably find another way of getting the material to your students. As with all law, there is no absolute black and white interpretation that applies in every case. This checklist serves only as a guide and a way of documenting your reasoning for making your decision. Of course, you are always 100% safe if you use materials that you or your school have paid the copyright owner for use in your classroom, or you use materials that are clearly marked as free to use for educational purposes. As an educator, you may find that your students are confused about the difference between copyright and plagiarism. Plagiarism is a form of fraud, like impersonating a police officer or giving false information to a bank in order to borrow money. Plagiarism is committed when a person takes someone else's work and presents it as his own. All your students have to do to avoid plagiarism is to clearly indicate when they have included someone else's words in their own writing. They can do this by placing quotation marks around their direct quotes that they've cut and pasted from somewhere else, and clearly indicated that someone else is the author of those words. Plagiarism is not against the law, but is considered a moral offense. Plagiarism may also be a violation of copyright law if the plagiarized material is also copyrighted. It is best to assume that everything that is produced by someone else is copyrighted unless it is clearly marked as being in the public domain. Just giving someone else credit for using their work does not absolve you from the copyright provisions of the law.